believes necessary for the proper carrying out of its functions.
Who would constitute the council in that situation to employ? And does that legislation have a defined set of persons who are considered a part of the council?
No, it doesn't.
Well, so not because it is there, it means that it makes sense. So who are the individuals in that entity who would employ the head of the agency? It can't be any lesser in terms of role that would be employing the head of an agency. So maybe we copied a legislation that is not necessarily fit for purpose.
That needs to be amended. Maybe.
I don't think it was a copy.
Just a suggestion.
It's based on
think,
drafting.
Yeah.
That's how it's normally placed.
I think the confusion came about because the JTC is the council. Yeah, and it doesn't have any legislation currently. We're creating it for the entity. Huh? Right, it must make sense, and I agree that the council can't do that function of hiring its own CEO.
In the definition area, it speaks to the council, means the Jamaica Teaching Council established by Section 6. Right. And in Section 6, Part 2, for the purpose of this act, there is established a body to be called the Jamaica Teaching Council, which shall be a body corporate of which Section 28 of the Interpretation Act shall apply. And it made reference in 6.2, the provisions of the third schedule. Now, the provisions of the third schedule now speaks to, seal and execution of documents, funds and resources, power to invest. Question, is there an area that speaks to the role and functioning of the council? Clause 7? Right.
And it doesn't state anywhere in there that.
So this speaks to now the functions. But in terms of the structure itself of the council, there's nothing. So maybe we need to consider identifying what would constitute the structure of the council, just to be clear, so that we are making the distinction. The board is defined in the first schedule. You see, the point I'm making, Chair, is that it's a new legislation, and it's a legislation that has been evolving based on the discussions that we are having. So we are building as we go along. And so we want to be able to satisfy that we are connecting all the dots. So maybe there's a consideration on defining the actual structure of the council itself. We might be assuming that there is one. Yeah, but the legislation doesn't speak to it.
Chair, it strikes me that we need to decide also whether we need both.
Member Brown, Dr. Gordon was on the microphone.
Oh, I'm sorry, I didn't realize that.
Legislation doesn't speak to the details of the structure. It speaks to the key positions. The CEO, the registrar, because we are going to license teachers, and the the director of corporate services. It doesn't speak to any other group.
So the reference of that is what is contained in 18.
And then now the structure is developed and approved by the Ministry of Finance and Public Service.
But the question has to do with the hiring of the CEO. But we have Member Brown needed to come in. Go ahead, Member Brown.
Yes, I'm saying, Chair, that an issue that we need to resolve is whether or not we need both the board and the council. And if we resolve that we need both, then we set up the specific role and function of the board as distinct from the council. But the issue that came up initially is that whether the two could do the same thing. And it's clear that it can't from what the technical people are saying. So the issue has to be, what is the role of a board if we need a board, as distinct from the role of the council, since it's clear we're going to need a council. And if we do that, we can then identify the specifics and frame clauses that meet those objectives. Thank you.
Just a question in relation to how other body corporates work in the hiring of staff, for example, head of entities. Is it that the Office of the Services Commission takes on that role? I think this is something that we probably need to explore or identify how it works in those scenarios. For example, you mentioned the Disabilities Act. Who appoints that head of entity? And then we can better understand why it is like this.
Process for all government agencies. And the Ministry of Finance, you have to have your staff approved by them. They have manuals and processes that guide the appointment of any person who's paid from the public purse. So that is set. And you can only make any changes if the Ministry of Finance and the Public Service agrees to those changes.
That's a different issue altogether, Dr. Gordon, because I appreciate that. Every entity has to be approved by the Ministry of Finance as it relates to their structure. Now, I'm talking more specifically about employment or engagement of the head of an agency that is a body corporate. Not all government entities are body corporates. So I'm just asking, how do other body corporates operate in a situation like this?
Member, I believe other body corporates have boards. If they're incorporated. Members. Let's agree that this council needs a board. Let's not get hung up on the word council. It's just the naming convention. It could have been Jamaica Teaching Board or Jamaica, it could have been something else. Huh? No, but it needs, yeah, it needs a governing. Can you get on mic, please? Okay.
Minister, the board appoints the executive director, and the executive director appoints everybody else on the council. So at the level of the executive director, the board would be the body to appoint that person.
I just want to be sure and to be satisfied of the distinction in roles, in that the role of the board is defined and the role of the council is defined. And it's my understanding that it is the board that has that overarching responsibility, but the council carries out the day-to-day operations.
Yeah.
And so there's no overlapping of functionalities. And once we can clear that up in our minds, then I'm good to go.
Yeah.
I think that's what we're all saying.
All right, to our technical persons, legal persons.
So we're looking at a similar legislation in order to correct the matter of the appointment of the head of the entity and then the other employees. So crave your indulgence.
All right, we're ready to reconvene, Council. Council?
Yes, Chair. So the discussion, based on the discussion, the proposal is to indicate at clause 18 that the board shall appoint the chief executive officer and the council shall appoint the attorney at law, the registrar, and such other officers.
All right, members, we're in agreement.
I'm not sure for those online if they heard.
All right, Member Miller, Member Brown, did you get that? Member Morris?
I heard.
Yes,
But
yes, Madam Chair.
Yes, Madam Chair,
Yes,
hearing.
Madam
Okay.
Chair, I heard.
All right.
Are they an
But I
agreement?
want to make it clear that I believe that we have to be very clear as what is the role of the board as distinct from the council. And it appears to me now that it's just the appointment of the CEO that may fall to the board. And is there a conflict in terms of the hierarchy, the board versus council? Are we satisfied that that has been resolved? Because the discussions, I understand it, is whether we could just call everything that the board was doing the job of the council.
No.
Is there a real distinction?
Yeah, Member Brown, it has been resolved. The bill will spell out the role of the council vis-a-vis the role of the board. And it is clear in other legislation as well.
In my mind, the distinction has been made. Right. We have in 13 what defines the board. We have in 18 the appointment of the council. I just want, Mrs. Gordon-Jones, you made mention of the council shall appoint and employ the CEO.
The board.
In 18. Right. So 18 speaks to the board. It says the board.
The board shall appoint.
Okay.
This is a correction.
That's a correction. Right. And then now, there's going to be an amendment to define who employ the others.
So I think the amendment would be 18. 18 will take care of all the matter of appointment.
Okay.
So the drafter will draft it accordingly.
Disaggregate.
Yeah, just a disaggregation.
Disaggregate the CEO.
Right.
Yeah, all right.
All right, so members, just to agree, yes, confirmed. That decision is confirmed about the board versus the council and the responsibilities of each. All right,
so,
council, please move
So, Chair,
on.
we are agreeing about reverting to the status quo in terms of not switching the terms. Okay, very well. Chair, there was the matter of the amendment to section clause 24. Where I think Mr. Foreman wanted to see what the draft would be before he agreed to what the provision read. I'm not sure if Mr. Foreman had a chance to look at it, but it was sent to the chambers by Mrs. Sherland. Or it was sent in an email which included the chambers by Mrs. Sherland. The redrafting was in relation to 23.5, subclass 5, where we had to take out the principal of the institution and just make reference to employer. So there was a change to subclass 5 and 6, and of course it was an agreement to remove subclass 7 and 8. The reading for subclass 5
Sorry,
said
that was 23.
24.
The first one, 24, 5.
The clause read, a copy of the notice under subsection 4 shall be served on the employer, and upon receipt of said notice, the employer shall forthwith ensure that the person who is the subject of the notice ceases to practice as a teacher until that person produces evidence that he or she has been granted a license or an authorization to teach. 6, a person who does not comply with a direction under subsection 4 to cease to practice as a teacher and continues to teach without a license or an authorization to teach commits an offense and is liable on summary conviction in a parish court to a fine not exceeding $500,000. That was the redrafted clause or clauses. Those were the redrafted clauses.
Well, it was really Mr. Foreman who had raised some concerns. I know we had a lengthy discussion around it. So it is for him to respond if he had seen the redrafted submissions. But I think I'm clear on it, Chair.
Chair, may I?
Yes, please go ahead, Mr. Foreman.
All right. Thank you and good morning. Yes, I looked at the document which Mrs. Gordon-Jones made reference. It appears to have covered the lacuna that I was concerned about at the last meeting. I'm not sure if the redrafted provision was shared with the committee itself, which I'd comment so that you can make a decision one way or another. But the provision that I saw appears to be okay.
Our counsel, do you want to just read again, just so we're sure? Page 4. Page 4 of the minutes.
Just to reread, a copy of the notice under subsection 4, so I'm reading subclause 5, A copy of the notice under subsection 4 shall be served on the employer, and upon receipt of said notice, the employer shall forthwith ensure that the person who is the subject of the notice ceases to practice as a teacher until that person produces evidence that he or she has been granted a license or an authorization to teach. 6. A person who does not comply with a direction under subsection 4 to cease to practice as a teacher and continues to teach without a license or an authorization to teach commits an offense and is liable on summary conviction in a parish court to a fine not exceeding $500,000.
No, I just wanted to recall if the trigger for committing the offense is if they were to continue to teach. In other words, that's a brazen act. And that would have been captured in the redraft. So I just wanted to confirm that, since I'm not reading it, but listening to it. I'm okay now.
So members confirming? 24.6. Section 24.6.
If you want.
All right, so confirmed by committee members. 24.6. Section 24.6 is confirmed. Yes?
We are continuing with the items for discussion under that document that we had left off on at the last meeting. So the other one was number 5, which Senator Brown, who is now back with us, we disaggregated the sub 27E to indicate the three requirements, or one of 3 requirements. So I'm going to read the entire clause. 27, a person is eligible to be registered as a teacher under this act if the council is satisfied that the person A has attained the age of 18 years, B, subject to paragraph C, has attained the prescribed qualification for registration as a teacher, C, has the English language skills, both written and oral, prescribed as suitable for registration as a teacher, D, is a fit and proper person to teach, E, has one of the following: 1, Jamaican citizenship, or 2, permanent resident status, or 3, a valid work permit allowing the person to work in Jamaica, F, is not a disqualified person, and G, meets any other prescribed requirements for registration as a teacher. So it was E that was disaggregated based on Senator Brown's suggestion.
What could be those other prescribed requirements?
You just leave on that catch-all. You leave that option for.
If somebody if say something, insert something.
No, but it, well, as a discretion.
When you say prescribed requirements, it has to be by regulation.
So the regulations would identify those. Okay. I just want to know that it's not something that somebody can just pick out from somewhere and decide as an institution.
So this would include requirements that may come up from time to time. That is put in regulations then. Maybe things that we have not contemplated now that may arise in the future. So it's a catch-all that assists the council in being flexible. Okay.
All right, members, clause 27E, we are confirming. All right, confirming clause 27E. All right, please carry on, Ms. Gordon-Jones.
The next item is item number 6 on the list of things for discussion. It says, consider whether subclause 43.2b1 should be removed or amended. 43.2b1. 1, Roman numeral 1. So I will allow members to find that provision and to follow with the response. And the response is, the proposal is to amend the provision to indicate that the council may decide not to grant the license if 1, the application is not made in the prescribed form and manner required by Section 36(1) or accompanied by the prescribed documents and information and the prescribed application fee and any other amounts payable to the council as the case may be. It's a matter of not granting the application. So currently, the provision reads, B says, decide not to grant the license if 1, the application is not made in the prescribed form and manner required by Section 36(1) or accompanied by the documents and prescribed application fee required by Section 36(2). It says that this language is similar to what obtains at clause 38.1, which indicates that an application under the concerned part shall not be considered. However, the concern is that clause 38, which treats with supporting documents for application, indicates inter alia that the council shall not consider an application unless the prescribed documents and information and application fee, among other things, are submitted by the applicant. It said the provisions under clause 43, which indicates that the council may decide not to grant a registration, that is 43.1b1, license 43.2b1, or authorization to teach 43.3b1, seem to be in conflict with clause 38.
Necessarily in conflict, it's just that there are the word information and any other amounts were missing, but now that you've included it, I think this is a bit cosmetic, so I'm fine with it, Chair.
All right, committee members, affirming? Yes, affirmed. Council? Go ahead, Council. Can we move on to the offenses, which constitute disqualifying offenses?
Item number 7. It was taken, Chair, but just to read it for the record. Clause 45 was deferred to the technical team for further consideration. The question was whether a teacher who was absent from teaching needed to be teaching for 2 consecutive years before that teacher could be considered for a license. And the response was the proposal was for the 3 years to be changed to 2 years, and this was agreed in previous meeting. Number 8. This was also number 8 on the document. Chair number 8, authority of the Professional Practice and Conduct Committee, whether the PPCC is to make a decision or recommendation to the council, having conducted the disciplinary inquiry. The response is the PPCC is to make a recommendation to the council for its consideration. Recall, Chair, that this was discussed and it was taken that they make a recommendation and then this will go to the board based on the change of the term. Board to council. So it would actually be that 31 persons. But based on discussions had this morning, I think it has to revert to the status quo for the count, for it to make a decision to the council. And then the council will indicate that decision.
Trying to get my bearings, Chair. So because we have two distinct entities, council, the board, each would have their responsibility. The board is who appoints the PPCC, right? Which means the PPCC are saying, no, when they make that decision, no, well, when they
consider the
matter, it is a decision that is made and then communicated to the council. Okay. Yeah. To the council. Because we're identifying it as an entity in and of itself. Which is what we wanted initially, I presume. Right.
Having considered the matter and make a decision, and someone has to act on that decision, and that would be the council. Right. And so the council, who in this case is using my term, the corporate authority, they would have to effect. And recall that the matter going to the PPCC would have come from the council initially, advising instructions for the PPCC to consider. So I think we have worked out the sequence of events and how they ought to be implemented. The council itself must not be given any prerogative to contemplate a decision again because you were never a part of it. So you can't be reviewing something that you would have given an authority to consider. And so once you get the decision, then your responsibility as the council is to act on that decision.
So we're right back where we... Exactly.
There's an appeals process as well.
So we're...
Mr. Foreman, please go ahead.
Sorry. Thank you, Chair. Senator Gale has made my job a lot easier. His recollection of what was agreed coincides with my own. So I can rest there.
Thank you, Mr. Foreman. Council, please carry on.
Number 9, the list of disqualifying offenses. The committee was to look at the list that was provided by Legal Reform Department in order to amend the definition of disqualifying offenses under Clause 2. And it's proposed for the schedule to be inserted on those offenses.
Good morning to everyone. This is Nadine Wilkins, Legal Reform Department. We had submitted...
Please put your camera on, Ms. Victim.
Oh, I beg your pardon. Sorry about that. Here I am. We had submitted the extremely lengthy schedule to demonstrate for the members the range of offenses so that they can in their contemplation understand whether they would wish for all of those, or we were thinking once you have been sensitized that what we could do is use general words, an offense involving so-and-so, an offense involving corruption, an offense involving sexual offenses, those kinds of language. Because as you can see, the list is long. And not every offense in the list warrants the complete exclusion for life, which is what we would essentially be providing. So the idea was that you'd have a look at it, get a sense of the kinds of offenses, and then we could approve some general language for the drafter to essentially connote the categories of offenses rather than that list being put in the bill. I hope that that is helpful.
Council, just looking at these, I mean, starting with an offense under section 9 and 10, we're not leaving that out. An offense under child pornography, under the criminal justice, suppression of criminal organizations, dangerous drugs.
If I could interject, Chair, one of the concerns is that we keep amending laws, and when we amend the laws, if we had put a section in the schedule at the time when the law is being amended, those sections would no longer be the ones that apply in relation to teaching council for the teacher being licensed. And so there's that danger, because we have that problem with other laws now. So like firearms that has been repealed and replaced. So provisions for offenses, lots of them now have to be amended.
Is it not possible to say on any amendments to these existing? I don't know, is there a language that if those acts change, then it would change in ours?
Well, I would ask, I defer that question to the drafter, Chair. If she thinks that is doable, then yes.
Good morning, Chair and members and colleagues. I apologize for being late. The issue you will have is, so under the Law Revision Act, if a name of an act is changed, like firearms, then the reference can be to the new act. The problem, though, is that you won't have the same reference to the section. And for instance, even with the new Firearms Act, the offenses have changed. So it's a new law. It was a repeal and replace piece of legislation. So even if you match up a related section with the old section, it may not even be the same offense. So you're going to have a problem trying to find some kind of technique to say it would refer to any subsequent change, because the subsequent change may be so different that it is possible you may not want it here. One technique, though, would be to allow for the minister to add to the schedule by an easier mechanism. So, with parliamentary oversight, so by order subject to affirmative resolution. So at least when there are changes made, you can then update your schedule. It does mean, though, and we use that mechanism in a number of laws. What happens, though, is that persons are so busy, they don't get around to bringing to the minister's attention that the schedule needs to be updated. So it would be something that would need to be present, and I would say maybe a yearly routine that maybe the LSU or somebody will undertake to just make sure that the schedule is is updated and remains relevant.
So could we put in this then a requirement to do that in much the same way that we require laws to be, okay, like on an annual basis? Except I've seen them put in different laws a requirement to review.
That you put in a legislation is the review period for the legislation itself. What SG is talking about in my mind is what would be administrative, that your internal person continues the internal reviews and provides the recommended update so that you can bring the recommended updates here for amendments.
Yeah, I get that. So there's no way
But
you
you're not
can
going
make
to
that a
find,
requirement.
yeah, I don't think you're going to find a catch-all provision that is going to cover that in its entirety. It just requires some work to be done internally to do so.
With government, I'm not very convinced that that will work. I'm not convinced that that will work. Internal mechanisms.
That is why I wanted to have something more that says.
My thoughts, Chair, on it, because I went through extensively all the pieces of legislation that have been highlighted. And there are some sections that I think could have been included in some of these legislations that are not. But I don't know if it makes sense for us to go through all of these pieces of legislation and identify all these sections that may be relevant. Because when we do that, we exclude others. That's my way of looking at it. So I would agree that we do something a little bit more general to cover the offenses that we would want to include. And I think on one occasion when we discussed this, I'd indicated that I think we should include also the Sexual Harassment Act that is currently not a part of the listing. Yeah, but it is still, I'm not going to say what I want to say on record. No. But it is still a piece of legislation that we could possibly include despite.
Work in progress.
Yeah.
Chair, just to respond, we had been selecting the offenses that were serious criminal offenses. That was the focus. So this is why we wouldn't have, okay, fine.
But is it possible, asking our counsel and technical persons, is it possible to say, instead of itemizing the sections, could you just list the act?
That would be not the weight that you're going to give. Remember that we're dealing with a situation where a person is potentially being told they can never enter a particular profession. When you're locking somebody out of a profession, it behoves us to ensure that the reason for that lifetime exclusion is such that it can be defended because it is a very serious criminal offense. So perhaps at a different level, the council can consider other kinds of offenses, perhaps if they are committed with a certain level of frequency, but it wouldn't be under, in our view, the provision that bars the issue of a license forever.
All right, members, do we go ahead with this list then, and if there are changes? Members, do we go ahead with this? Go ahead with it, meaning we accept this as part, huh?
Not in its current form, Chair. As was identified, I think we should try to condense it. I think we should try to, it is a bit lengthy to put into the legislation as a schedule. I don't know, that's my opinion. But for example, so when I went through the Criminal Justice Suppression of Criminal Organizations Act, there are a number of sections here that were highlighted. But I am of the view that section 10.2 should have been included, which speaks to harboring or concealing a person part of a criminal organization. No, that's not a part of it. But if we continue to itemize, I think we get ourselves into problems.
Chair, section 10.2 is included.
10.1 and 6.
And then 10.2 and 6. It's at the very bottom on the first page.
Chair, I suggest that we go with SG's recommendation, noting that there are emerging crimes as well in the digital space. So we can't be too fixed on a document, but have a general legal statement which Ms. Sherland, I'm sure, can draft, and we should give the flexibility that when the changes are made, the person in the agency who follows the law will be able to inform of changes made. And also, the restitution, there's restitution in the Jamaica Teaching Council Act. There's restitution. So there's a period when the person can reapply to become a teacher, and the person can prove that I'm not on the straight and narrow. Learned friend here says it's reinstatement.
Gordon, I think we're talking about two different things, Dr. Gordon, because the whole reason for us going through the disqualifying offenses was that persons cannot be reinstated after these. So, for example, after you rape somebody, there's no way you can come back into the classroom. So that's why we went to length to identify these disqualifying offenses. But you can be reinstated after.
I don't know, it has to be considered at the level of the council. You don't need to put it in law that if you rape somebody, you can't go back to the school. That is because education also has an ethical dimension. So you can win a case in court and you still can't go back into school.
But I think the law should be very clear on certain offenses.
I Member Crawford, we're hearing you.
Yes, I was saying I believe that the law should be very clear on certain offenses. And by the way, I want to apologize for being late. I had an emergency situation I had to deal with in the constituency. So I really don't think that some things should be left to the council. I think the law should be very clear on some of the disqualifying offenses.
We agree with you, Member Crawford. We're just looking at the how. How do we get this in? And what do we do when the laws, these disqualifying offenses, if there are changes in it, how do we get those changes into our act?
I really don't think we should go back into this discussion of revocation and reinstatement because we've ventilated that at length. The whole reason why we decided to identify offenses is because we had agreed that these disqualifying offenses, if your license is revoked, then you cannot re-enter the classroom. But if there are offenses outside of the disqualifying offenses, then you can apply for reinstatement. I think that was right.
But I think what we're trying to get to is how do we put these in the act? What's the reference? Right, SG? How do we reference them?
We went through every item in this document, one by one, to see what likely impact anybody who has committed any offense would have on children in school in terms of rules, regulations, conduct, and so on. And at the end of the year, we decided to keep all of them. We decided to keep all of them. The disqualifying offense.
Chair, we wouldn't be able to keep all of these offenses. For example, the Larceny Act. It has here larceny of dogs, 7. I really don't believe that we should revoke somebody's license because they stole a dog, for example. So I'm saying we have to really condense. Yes, but I mean, yeah, but this is an offense.
So
I think no, but this is an
thief.
Yeah, but so you're proving my point then, Dr. Gordon, because I'm saying this is an offense where you can now, after a period of time, apply to be reinstated. A larceny of a dog, for example. Well, that is for the council to determine, based on the information that the person would have submitted for reinstatement. But I don't believe that somebody should be permanently removed from a classroom because they may have taken a dog from somewhere. I think that's a bit harsh.
Stealing is not what the person steals. It's the act of stealing.
No. Public nuisance. Come on, man. What we're doing here is that we're seeking to capture an expansive set of legislation that have within them certain offenses. That I'm not seeing some of these offenses that should prevent or prohibit someone from carrying out their profession.
Yeah. So we have to identify.
So public nuisance.
Could we go through and mark off then if that's where it comes down to?
I would prefer, Chair, that we stick to those that would appear egregious in nature. Grave. Yeah?
Because they're not coming back from it. They're not coming back from it. So Chair, remember, remember that there is the situation where somebody can be suspended for a period of time in the classroom. So if somebody steals your Dalmatian and you report that person, then yes, they can be removed from the classroom temporarily and then can apply to be reinstated after a period of time, after, I don't know what processes would have taken effect from the theft. But I don't believe that, and as Senator Gill was saying, public nuisance. I mean, it depends though on the gravity of it. But I don't want us to start nitpicking and going through every possible scenario that can possibly take place, because It would make sense. So I'm in agreement with going through identifying the serious offenses, not necessarily applying sections to them, but highlighting, for example, offenses relating to children, rape, murder, however we want to do it. The drafters would be able to give us, pardon me, Chair? Drugs, exactly, things like that. But for us to go into all of these, I don't think it would be fair.
Yeah, you know, teaching is not just teaching a child ABC and 2 plus 2. Teaching is a profession that is set up to bring up a set of human beings, and to bring up a set of human beings with certain values, certain accepted values. And when those values are breached, they are breached. It is a breach of professional conduct. And so we don't want to look at it and say, this is small and this is big and this is medium size. There's a breach of professional conduct, and that has consequences. It is for that reason why the teacher is appraised every year for professional conduct, because the teacher has a fundamental responsibility to the nation to bring up the children of the nation with certain values and morals and understanding of relationships and how we survive as a sustainable society.
I am in total agreement with Dr. Gordon. I think for the first time we see eye to eye. And that is why it was important for us to have teachers get police records. However, what Dr. Gordon just mentioned, yes, I can identify values that maybe must be imparted to children. But the revocation is not the only mechanism under the legislation that can deal with offenses. So we are now talking about permanently removing somebody from a classroom. If the offense is not one that is particularly egregious, and there are other disciplinary actions that can be taken, remember the person can be suspended for a particular period of time. Now that removal in and of itself, I think, sends a message. Yes, I just don't see why we should remove a teacher for some of these offenses that have been highlighted. I mean, there are not a lot of them that I think are, but we probably need to just go through to see if we definitely want to keep some of these.
Senator Spence. Sherry Spence, please go ahead.
Hi, good morning, everyone. My name is Sherry Spence from the Legal Reform Department. I just also wanted to indicate that regarding Clause 27F, this would also have implications for whether or not a person is eligible to be registered as a teacher, because Clause 27F indicates that a person would not be eligible to be registered as a teacher if that person is a disqualified person, and a disqualified person is also defined under the Act as someone having committed a disqualifying offense. Also, in respect of the Sexual Harassment Act, it's not an act when we looked at it, we did not find that it was an act that criminalized sexual harassment. There are certain offenses which are provided for in the act, but it does not it doesn't create an offense of sexual harassment, not from what we saw when we looked at the act.
How would we treat with sexual harassment in schools, for example? I understand what was just explained and highlighted, but these things happen in schools. So how would we treat with it, is my question.
Nadine
Just to
Wilkins,
take
just
the
as a,
last, go
ahead,
okay,
Sergeant.
just to take the last issue first, and then I have something else to say. The Sexual Harassment Act actually has a whole scheme relating to schools and educational institutions, including tertiary institutions. So to me, the answer would be that the schools should ensure that they have their policies established in accordance with the Act, and then they would apply that Act, which has a mechanism which allows for complaints to be made, and there is a review and there is a tribunal. So there is a scheme. Yes, so as part of the not just the ministry, you're setting up a council and a board. I would say that it would, to me, a part of this regulatory framework would be that this council would know that they are also to assist in ensuring that they are doing what they're supposed to do. Because the council is basically the regulator. That's what you have set up here.
I thought I thought we allow persons to bring a report to the council for investigation. And then it was the council that decides, right? No, I think we're going back. But we do allow that to be an avenue available to persons.
That's not where I was going. That is true. But I'm saying the mechanism under the Sexual Harassment Act could be used. But I'm saying also that the council, as a regulator, also to me has a duty to ensure that the schools are doing the things they need to do. For instance, it's not just the ministry, but the council who would be ensuring that a school has a sexual harassment policy. Right, so I'm just saying it's not just on the ministry. I think the regulator also has a duty. But to go back to the bigger issue, and I understand Dr. Gordon's views, but I think her views are in the context that there would never be a full disqualification of a teacher. But I think from my understanding, the committee has taken that decision that for some offenses, this person can never, ever re-enter the classroom and never, ever be able to, they could apply, but they would never be able to be considered for registration. In that situation, and I note the member has been referring a lot to fairness. It's a very harsh penalty to take away someone's livelihood forever. And so I would suggest that you go with a shorter list for now. You see how that works. You have a review, as you pointed out, Minister, you have a chair, you have a review mechanism in your law. You see how the law works over time. I would suggest you keep that list very short. And it should be of the most egregious sort of offenses: murder, kidnapping, treason. We have acts that will list some very basic but very egregious offenses. I would suggest you take that route and see if, and when you're doing the review, you will then see what has happened during the period. Is it that there have been issues with persons who were convicted coming back in and creating problems or not? You may want to revise that list. And even with that list that I'm suggesting, you could still have a mechanism. So you would put the list in a schedule, and you would also say that the minister has the power to amend that schedule by order, subject to affirmative resolution. But I would really suggest, rather than including things such as, yes. So as egregious as, look, it is wrong if someone has been convicted of a criminal offense and think they can just walk right back into a classroom. But it's not an automatic process. But to say that you're going to take away their livelihood forever, it really should be only limited to the worst of the worst. And in that list, I'm not sure. I would suggest that you consider just criminal convictions for now, and leave the other matters to the other mechanisms that are available. So that's just my suggestion, Chair.
Please go ahead, Ms. Wilkins.
But the sergeant said some of what I was going to say, Chair. But I was also thinking if another approach would be to say that the disqualification would apply if the offense had been committed in the last, say, 10, 15 years. For some of the offenses that are not as serious as the sexual offenses, I think the sexual offenses shouldn't have any limit on them. The child pornography, certainly not. But I don't know, the criminal justice suppression, maybe you were in a gang when you were 17, 18, you are now 35 years old and you have left that life behind you. They could be considered because that period has elapsed and you applying the fit and proper criteria, the council is satisfied that you're a different person. That was another approach I wanted to put forward. Thank you, Chair.
Ms. Crawford, do you have further intervention? If so, please go ahead. Member Hamilton, I'm going through the list. I don't see any that I want to take off yet.
And the fowl and goat and those things, honestly, I don't even think it's relevant. Because teachers not doing that.
So again, since, you see, to me, it would be different if the committee's decision was not that, if you have committed it, you would never re-enter a classroom, you would never be able to register. And this could have an impact for you, not just in Jamaica, but elsewhere. But the committee's decision being what it is, just taking, again, the same Anti-Gang Act that Ms. Wilkins spoke of, I don't know that you should punish someone who was a part of a criminal organization, the same as someone who was convicted of leading, managing, or directing that criminal organization. To me, if you were the head of a gang, or you were recruiting children.
But no, come on, guys. We're being soft on crime right now. We're talking about children in a classroom.
No, so that's why I'm saying those persons should be barred. That's what I'm trying to say. Okay. That the person who was recruiting the child, but I don't think you would punish that person the same way as someone who may have been a member.
But there's no in between.
Yes, but there is, because remember, this is the extreme punishment that you're going to mete out to someone who wants to be registered as a teacher. Remember, you have other mechanisms in the law. You have a lot of other mechanisms to deal with persons who may have run afoul of the law, but then you're going to give them an opportunity years later to be able to submit an application and be considered. And just because they're being considered does not mean they will automatically be registered. So, Chair, and then even if you don't take that point, so because you stole and destroyed fish, it means that your livelihood should be taken away forever. I think that's very harsh.
Whose fish you stole and destroyed? Somebody else's,
yes. Right? But I'm saying, and that is a reason why
depriving those persons of a livelihood.
And so that is the reason why 30 years later you also don't get to earn a living. And then how do you contribute
not as
to
a teacher? Teaching is not the only profession.
Wow, okay.
Teaching is not the only profession, and we are saying, find another profession. We have to be serious. Come on, when lawyers, well, if you're a lawyer and you are disbarred, do you go back? It depends, right?
What this is depicting, and it's clearly defining that once we put it in law, once we put it in law, it means that you would have created a barrier to those teachers being able, at any point in their life, to participate in the profession or to carry out their career. And they are so wide, these offenses are so wide in nature. Again, under offenses at common law, public nuisance. I can play my music loud as a neighbor, and it was reported to the police and I was warned, but I would have been charged for public nuisance. Does that keep me out of the classroom as a teacher? Remember, we're having thousands of teachers with thousands of different minds. And as the Solicitor General has clearly indicated, there are other provisions within the application of the law to treat with any of these offenses. Internally, even the same role and function of the PBCJ, if a matter has been brought before the council to be investigated and to be considered, the PBCJ would make a decision on some of these issues. I don't believe, I saw the one with the fish kill. And yesterday there was a report in the media about a fish kill in the Bagua Gorge. So suppose a teacher may have been involved accidentally in a fish kill. It speaks to fish kill.
Huh? So it would bar that person?
It would bar the person.
Yeah, but it doesn't.
It's not going to define.
Exactly.
It's not going to define how the act took place, It's going to
it's not the mens rea.
determine that the act actually took place.
Right. There's no mens rea considered in these here. So once you put fish kill, then there's no way of coming back.
Manslaughter. So you have a car accident that you hit down somebody and it caused manslaughter. And you are going to serve your term. But when you come out, it does that mean because the accident took place, you're going to bar that individual who was a party to an accident from continuing the profession. The result of the accident, the car accident, led to manslaughter. Someone died. Are you going to bar that individual from continuing the profession? So I'm saying that there are some offenses that are contained under what is being proposed that stretches itself too far in barring the person from becoming a teacher or from continuing to teach. And I would suggest that we consider those that are egregious in nature, those that are violent in nature, as part of the first instance of consideration. Now, additionally, a submission would have been made that, Chair, this is a legislation that will evolve. So as we progress, we may see other instances of offenses that might perpetuate themselves on more than one occasion. And so as minister, you would have the opportunity to amend the provisions to include those that we see. But as a member of the committee, I'm not going to start out by supporting a list of offenses that are so expansive in nature, that is going to rule out someone from being able to practice as a teacher. But at the end of this, it really determines on the point of the committee making the decision. And I'm expressing my concern as a member of this committee that I'm not going to support this expansive list of offenses in making a determination.
The bill allows for a person who has been removed from the profession for one reason or the other, whether it's a big crime or a small crime. The bill allows for that person to reapply to enter the profession and for the application to be considered.
Chair, we made a decision on that months ago in relation to reinstatement, and that is why we're here, Dr. Gordon, with the disqualifying offenses. Right. So we're not going to go back in that discussion. We're just trying to move forward in relation to how we proceed. And Chair, I'm in agreement, total agreement with SG's recommendation as to how we proceed, because I think that is the most practical.
Chair, I was just about to say that as well. I think we should really go with SG's suggestion that if we want to include a list, we should keep it as minimal as possible and only the worst of the worst. I think that's really the best approach at this time.
We can go back over the list and prepare a much shortened one, Chair, that is representative of the offenses that can be regarded as extremely egregious.
Definitely, that's what we should spend some time to do, I think.
Yes.
Heard Ms. Wilkins is saying is that they are prepared to review the list and to get back to us with a revised list that may very well exclude some of these offenses that are not egregious in nature. Isn't that what you're saying, Ms. Wilkins?
Yes, Senator Gale, that's what I'm saying. That,
but having given us this... Go ahead, Ms. Wilkins, sorry.
Yes, so I'm saying, having regard to the points that are being made, I see the SG's point about the dynamism with which we have to treat with these things and the constant review. So the discretion that is being proposed to be given to the minister will afford a constant opportunity to go back over the list, take out, add, as we go along.
Cherise, please go ahead.
Thank you, Chair. I just wanted to indicate that regarding the way forward, we'd have to now look at the definition of disqualifying offenses under the Act, because that is precisely why the LRD had prepared the list, given the definition of disqualifying offenses. We wanted to demonstrate the types of offenses that would be captured by virtue of this definition. So the list really was prepared to show members that it is quite exhaustive when it is defined as an offense for which somebody could serve a term of 2 years imprisonment or more. So I believe that the definition would have to be re-examined.
This thing, it is there defined. Now, I am not a lawyer, and I'm questioning, why do we have to write disqualifying offense? Why can't we say offense and leave the council and the PBCJ and all of them to decide what offenses would disqualify a teacher from the profession? I'm going to tell you why. You know that a teacher can carry out an act in school, and the teacher goes to the court, and the court says, under the law, this person is an adult, and therefore the teacher has not committed any criminal acts. However, as an education ministry and as an educational institution, you cannot put that person back into your school. You can't put the person back into the education system. And there are behaviors like that because we have children in school up to 18 years old or 19 years old.
All right, based on what Ms. Shireen said. Huh? Oh, sorry, did you want to? Oh, sorry, go ahead, Ms. Gordon-Jones.
Chair, just to remind the committee, there was an instance where a teacher was charged, a principal was charged with indecent assault of a minor, and the principal was not given a 2-year sentence. It was suspended for, I think, 8 months and 1 year imprisonment, and so that would not have met that 2-year threshold that we have set, and so that is why we need to carefully consider how we are framing the definition, because that teacher, based on that, would be allowed back in the classroom, which we would not have wanted. The other matter, Minister Chair, is in relation to the suspension or revocation of the registration license or authorization to teach, and the whole matter of suspending in relation where the teacher or instructor has been charged with a disqualifying offense. That's what it provides now. But Minister, you may recall the gap in the system currently where if a teacher is charged with an offense and it's before the court, there is no provision to suspend that teacher, and something similar to an interdiction, but I don't think we want to use that term. But there is this gap in the system now where if a teacher is before the courts on a charge, they have to be placed on either special leave with pay, or so there's no provision to suspend them in that regard, only if there is a disciplinary proceeding that will take place against that teacher. And so in the bill now, the suspension is only in relation to a disqualifying offense. And so I'm suggesting that the committee reconsider to include not only a disqualifying offense, but just an offense.
So moved. Yeah. All right, so I was saying that, all right, given what Shireen said in terms of the LRD trying to put forward an extensive list for our consideration, and that the LRD could refine and come back, I'll allow that. But there are very few, maybe one or two, that I would cross off of this list. Maybe one or two. Hold on. Ms. Gordon-Jones, for the record, could you repeat what you said about the disqualifying offense, moving to offense? Yep.
I think it's clause 59, which speaks to suspension or revocation of registration, license, or authorization to teach. The provision currently indicates that the teacher or instructor, the license or authorization to teach or the registration may be suspended, having been charged with a disqualifying offense. So the suggestion is for it to be changed to not just a disqualifying offense, but an offense.
All right, so we can round robin the disqualifying offense, the revised disqualifying offense list. We'll round robin. Members, will allow LRD to refine the disqualifying offenses, and then we'll round robin it with the members.
Oh,
Yes, Madam Chair.
And Chair, not to forget the point Ms. Spence just made, that the definition, we'd have to settle the definition of disqualifying offense, so that it's reflective of this approach. So the two things need to be done.
All right, could we have something from council on that definition? Go ahead.
Madam Chair, the definition would simply be disqualifying offense means an offense specified in the first schedule, and then you would drop the list in that schedule.
Okay, all right, thank you, members. Agreed to the definition? Disqualifying offense means an offense under this list of disqualifying offense.
That would remove the threshold from being 2 years. And so it's dependent now on the offense itself. Okay.
All right, so LRD, please take a look again at the disqualifying offenses with an eye to revising. And when you send back to us, members will round robin.
Yes, Chair, we will.
Thank you.
so lonely.